Good evening, this is John Milburn for Laws 11059 Statutory Interpretation. This is Week 8 in Term 3, 2017-2018. We have a number of people online. Thank you very much for attending. And those of you that are watching the recorded session, please give consideration to attending live. We always enjoy having a number of people attend and provides us with an opportunity to explore some of the topics in more detail. Now, the topic for tonight is extrinsic materials. It's based on Chapter 8 of your textbook, Michelle Sanson. And this is an interesting area of practice. I'm going to ask you to answer a question about yourself and your approach to the practice of law. Again, you know that I pitch the subjects the units that I take as if you are going to be in practice. So given that there are an extraordinarily large number of resources that one could categorise as extrinsic materials, do you regard yourself as a lawyer where referring to extrinsic materials is like a legal goldmine or a legal headache? Do you understand what I'm getting at? So if you're arguing a case and you know that you're able to refer to extrinsic materials, is that a good thing or a bad thing? You can answer it. Needs to be a balance. That's a good
I would say it depends on what the first impression gives you with regards to the argument you want to make.
That's a good approach. So the flexibility, all right?
Yeah.
So Jess says needs to be a balance. Sarah says be flexible, depends on what suits at the time. I think that's probably a good approach. Both of those things are a good approach. So when we look at extrinsic materials, it does provide you with an opportunity to argue your case from a perspective of relying on outside material, extrinsic to the act itself, to assist you with your argument. But if it doesn't assist you, you don't have to rely upon extrinsic materials. So ask yourself, is this a legal goldmine or a legal headache? The other question that I'm going to pose for you when considering the issue of extrinsic materials is this. As you know, we are advancing the plain English drafting approach to the practice of law now. What that means is that when we're writing material, we intend to do so in as plain and clear a style as possible to communicate this information to the end reader so that the person receiving the material can read it and understand it and apply it. Now, how do we reconcile the use of extrinsic materials in the context of interpreting legislation with plain English drafting techniques and the desire to make what is written comprehensible and, if you like, succinct and complete? How do we reconcile those two things? Do you see what I'm getting at? On the one hand, I'm teaching you to write in a way which is comprehensive, complete, and understandable. On the other hand, I'm saying when you're doing your legal research or advancing an argument, look at what is read, but don't accept it necessarily on face value. Look at it within the context of the act as a whole. And now I'm saying go beyond that and look at extrinsic materials. Doesn't one defeat the argument of the other? Anyway, just a thought. That's something for you to consider. And again, it might be dependent upon the approach that you intend to take at any particular time. Okay, here's a third issue for you to consider in the context of extrinsic materials. I want to ask you to pretend for a moment that you are advancing an argument based on statutory interpretation principles before a judge of the district or Supreme Court, let's say. And you argue that a certain section of an act should be interpreted in a particular manner. You consider each word in the section, as we're required to do. It was Project Blue Sky, wasn't it, where the court said you must consider every word within the section. So you've done that. You've considered the context of the act. you're considering each word within the section of within the section that you're arguing about, and you're advancing an argument. And to do that properly, you want to introduce extrinsic materials. You argue that a certain word should be interpreted by the court in a manner that you advance, partly because you rely on dictionary meanings and you tender the dictionary meaning from the Oxford Dictionary as to a particular word. Now, here's the scenario. The judge says to you, why should I take any opinion of what's written in a dictionary? Isn't that just someone's opinion as to what a particular word means? Can't I just work that out for myself? So what's your argument? If you really want to advance that the meaning given to a word in a dictionary should be considered by the court, what's your argument? Argue the ordinary meaning, which is good, but the judge says, yes, I can read it. I understand what the ordinary meaning of this word is. You don't need to show me a dictionary. So that might be something that is actually proposed to you against your argument to advance the dictionary meaning. Any other thoughts? I'm not necessarily looking for an answer here, but I'm asking you to consider these things. The context in which the word is used. So you say, Your Honour, in order to properly understand the context within which this word is used, I must refer you to the Oxford Dictionary. Is that the argument we're promoting? Maybe it is. Okay, so think about those things while you're doing your reading and ask yourself, how would you answer these sorts of questions if you had to deal with them in an exam context or in a court context, for example? All right, so extrinsic materials. What do we mean by extrinsic materials, and where do we look to find out the definition, if you like, of extrinsic materials? Any thoughts? What's an extrinsic material? I've scared you all off, haven't
I? Second reading speech.
Yes.
Explanatory notes.
Yes. Which are really examples, aren't they? Of extrinsic materials. Yes, Sarah?
Extrinsic material are materials that are used as support to a piece of literature, any external material to the actual text of the statute, which includes things like the second reading speech, the explanatory memorandum, reports, parliamentary reports, treaties or documents specifically referred to in the Act.
Okay, so in a way, it would seem that you're promoting the argument put forward by Tanya that extrinsic materials is, or at least includes, second reading speeches and explanatory notes. I get that. I'm going to ask you this question. I'm full of questions tonight, sorry, just to get you thinking. Isn't the opposite of extrinsic intrinsic? Would we agree with that proposition? Would we say that, can I take that proposition further and say that anything which is not intrinsic must therefore be extrinsic? Can I go that far?
There is limits to intrinsic materials.
Okay. What do we mean by that, Jess, that there are limits to intrinsic materials, if I heard you correctly?
Sorry, I'm talking to myself.
Which is fine.
It's just like in section 15AB3, it says that in determining whether consideration should be given to any material in accordance with subsection 1, then it goes on to say to rely on the ordinary meaning conveyed by the text of the sorry, I think I found the wrong section.
All right, so you're talking obviously about the Commonwealth legislation.
Yeah.
You're talking about the Acts Interpretation Act.
Yes.
And as did Tanya previously, you're referring us to section 15AB.
Yes.
So that's good.
But,
That's good. All right.
Number 3 with the...
Subsection 3, yeah.
Yes, that's the one. Yeah, no, but it just B, the need to avoid prolonging legal or other proceedings. No, I've lost it. Sorry.
I think you're looking at subsection 2, not subsection 3. I think you're on the right track by looking at subsection 3. Okay, now has everyone, while we've been discussing this, Jess and I, has everyone been calling up section 15AB, Commonwealth Acts Interpretation Act on their computer? All right. So I'm just going to park that for a moment and come back to the original question. So I think you're on the right track, Jess, and Tanya was promoting that as well. But the question I have is this. Are the terms intrinsic and extrinsic complementary in the sense that a material relied upon the court to interpret a statute must either be intrinsic or extrinsic? I think they are. I think they're separate. So intrinsic materials essentially are those things which are contained within the Act itself. Would we agree with that as a broad proposition? And extrinsic materials are materials that are not contained within the confines of the Act, as a general rule. But my question is this, and it comes back to the issue of the dictionary. How far can we go in arguing that a material, which is not intrinsic, is appropriately to be considered by a court in determining whether or not, in determining how to interpret a section or of an Act? Okay, so for example, if you're arguing a case to do with instalment contracts under the Property Law Act, for example, and you say that a particular word has a certain meaning and you rely upon the writing of an eminent academic writer and a textbook, and you say, Ronna, I refer you to page 217 of this textbook and this passage where the author has said in relation to section 74.2, is it 74 or 174? Or 71, sorry. This is the meaning that should be given to instalment contracts. Now, is that an extrinsic material, a textbook? Can I use it? And while we've been talking, Sarah says any material may be admissible, but like with evidence, the weight of the submission depends on their veracity. Okay, so Sarah would say that extrinsic means anything other than intrinsic, but there is a question of the weight, which depends on how accurate and reliable the information might be. Nicole says the list in section 15AB subsection 2 is not exhaustive, so that may include a dictionary or any other text. Okay, so what I'm really getting at is this. If you're challenged about something that you put forward to a judge, where the judge says, why should I read this? What's your authority for putting forward this material as being appropriate for me to consider in the context of trying to determine what this section is about? You need to have your answer sorted. And I think, Nicole, you're right. Section 15AB, subsection 2 of the Commonwealth Act is not exhaustive. But if those of you, if you're reading at section 15AB now and you look at subsection 2, isn't there a theme that runs through it? And if there is, what is the theme? While you're looking at that, I'm going to have a sip of tea. Okay, so Sarah says these are documents relating to the court and legal proceedings. Nicole is more general in the response, saying the material must be relevant. So when we look at subsection 2 of 15AB in the Commonwealth legislation, you are correct in saying that Nicole said it's not exhaustive, so it's providing simply some illustration as to what is meant, but it's not exhaustive. But if you look at that list, they all relate to things which are created by bodies which have certain authority conferred upon them. So we're looking at reports of royal commissions, parliament, treaties, explanatory memorandum relating to a bill, speeches, documents declared by the Act to be relevant, and material in the journals of the Senate of Parliament. See, I don't see in that list dictionaries and the writing of academics in relation to a certain area. When it comes to international law, just as an aside, the writings of eminent jurists and academics is actually specifically mentioned as something that is part of the international law. Anyway, I'm not necessarily giving you answers, but I'm asking you to consider these things so that you have a response available to you. And if you're arguing that the court should consider something about dictionaries in a Commonwealth matter, I think you need to be aware of section 15AB. I think you need to be aware of subsection 3, which provides the reason why the court should have regard to certain matters. And in doing so, be aware that that material should be given in accordance with subsection 1. And as Sarah said, the weight is relevant as well, but be aware of the limitations in subsection 15 AB, subsection 2. All right, I've been doing a lot of talking and you've been very patient, so thank you for that. Any questions so far? All good? What's the counterpart of section 15AB in, say, Queensland? Or if you're not in Queensland, you can tell me about the counterpart in your state. Okay.
Section 14B.
14B says Jess, and Nicole came in just at the same time and said 14B subsection 3. Okay, so Queensland, what act are we talking about? Pretty easy question, that one.
Acts Interpretation Act.
Yeah, the Acts Interpretation Act. Okay, so section 14B deals with the use of extrinsic materials interpretation. Is that section the same as section 15AB of the Commonwealth Acts Interpretation Act? Or are they similar? Similar, says Melissa. Yeah, I think so. But probably similar to the point where the differences are not substantial. But they're not identical. All right, so in section 14B of the Acts Interpretation Act of Queensland, it provides that subject to subsection 2, in the interpretation of a provision of an act, consideration may be given to extrinsic material capable of assisting in the interpretation of certain things. When you read that, it almost means that you've got to read it in segments in order to understand it. So the first thing is subject to subsection 2, these things happen. The way I read these pieces of legislation is I get to that point and then I read subsection 2 before I go on. That's the way I do it anyway. So subsection 2 says, in determining whether consideration should be given to extrinsic material and in determining the weight to be given to that material, regard is to be had for certain things. I actually stop there and think about that before I move on. And a few questions. You see, it's written in the passive voice, not the active voice. So I ask myself whether consideration should be given to extrinsic material. By whom should this consideration be given? So if this was written in the active voice, who would you say is the person, the organisation or the body that must give consideration to extrinsic materials in certain circumstances? Does that make sense? Who are we talking about here? Who should give, in determining whether consideration should be given to extrinsic materials, by whom?
Would that be the courts? Like the...
Yeah, ultimately the courts, but I think probably we could go broader than that and say by anyone, as students, as practitioners, by members of the public, but ultimately it comes down to the courts. So Michael says Section 19 is the counterpart in Western Australia and the person trying to introduce the point. All right, so in determining whether consideration should be given to extrinsic material or the weight of that material, let's say the court has to regard a number of things. The desirability of the provision being interpreted as having its ordinary meaning, and the undesirability of prolonging proceedings without compensating advantage and other relevant matters. It's all very tricky, isn't it, really? If you try and put that in the context of how you would answer questions about why a dictionary should be considered by a court. So let's look at that. You're trying to argue that the court should consider what's said in the Oxford Dictionary. Subsection 1 says the court may give consideration to this extrinsic material in certain circumstances, but it's subject to subsection 2, where in order to give consideration, the court has to consider the desirability of interpreting it in its ordinary meaning, the undesirability of prolonging proceedings without compensation, and other relevant matters. I'll just stop there. I know this is hard, but you're doing well. Dictionary. You're trying to argue that the court should consider a dictionary meaning for statutory interpretation. Look at subsection 2. Is there anything in there, in that subsection, particularly subsection 2A, that might assist you with your argument?
A dictionary holds the ordinary meaning.
That's it. That's exactly what I was after. Thank you, Jess. I think that is the answer. So if I was being challenged by a judge as to why the court should consider a dictionary meaning, given that dictionary is not included in the list of extrinsic materials that are referred to in, say, subsection 3 of 14b, or subsection 2 of section 15ab, I would say that before the court should consider that list of examples as to what is meant by an extrinsic material, the overriding consideration for the court is to give due regard to the desirability of interpreting something having regard to its ordinary meaning, and the best place to determine the ordinary meaning of a word is a dictionary. So therefore, the court should consider the dictionary even though it's not listed in as one of the examples in subsection 14b3. Does that make sense? Okay, so that's the sort of thing that I want you to consider when you're reading the material, asking yourself, how would I argue for this to be introduced and considered, and what are the likely impediments for that argument being successful? Okay, let's just continue that exercise a little further. We're looking, say, at, you can either look at 15AB Commonwealth or 14B State, or if you're in Western Australia, section 19. Thank you, Michael. So now we want to introduce a textbook, and the court sort of jumps ahead of itself and looks at subsection 3 of 14b and says, well, there's nothing here about textbooks being included. by way of example of an extrinsic material. So why should I consider a textbook?
Could it be from subsection 2C because it's relevant?
Yes, I think that's right. You say the writing of a well accepted and respected academic is a relevant matter. I think also you could argue that the court should ensure that should be aware of the undesirability of prolonging proceedings without compensating advantage. If the matter is relatively straightforward, relatively simple, then you could argue that the court should consider the textbook writings of an academic rather than necessarily going through a prolonged process of considering, amongst other things, reports of committees of legislative assemblies, because the academic work has been done and condensed in an opinion, which ultimately, if accepted by the court, will have the effect of avoiding prolonged proceedings. In other words, there is a compensating advantage of considering the academic writing, which makes it such that the court should have regard to that extrinsic material. Does that all make sense? They're just arguments. I don't have any authorities to back them up. If, when you're doing your reading, you find some cases where the courts have considered, say, extrinsic materials that are not listed, by way of example in, say, subsection 3 or subsection 2, as the case may be, then think about how it is that the court got to receive that material and what arguments may have been put forward by counsel to support the court doing so. Okay, well, again, you've all been very patient. You're all doing well. Any questions, comments? All good? All right, so actively read, if you would, section 15AB of the Commonwealth legislation and 14B of the Queensland legislation, or your counterpart. And leaving aside the fact that in the exam you will have a question about a particular piece of Queensland legislation, generally speaking, any answers that you provide to me, I'm perfectly comfortable with you putting forward material that's based on your own state rather than necessarily Queensland. Okay, let's think about some judicial comments in the context of extrinsic materials. Mills against Meeking. Mills and Meeking, 1990, 169 CLR 214. This, I think, is one of the go-to cases in statutory interpretation. And in your toolkit, you probably refer to some of the go-to cases, some of the quotes. We've mentioned one of them tonight, Project Blue Sky, and that general principle that the court should consider every word in a section. That's kind of a go-to case and a go-to phrase that you want to keep up your sleeve. Mills and Meeking said, if the language is clear and the purpose expressly stated in the Act, there may be no cause to refer to extrinsic materials. So if your opponent wants to introduce dictionaries, academic writings, consider speeches that were undertaken on the process, consider reports through standing committees, etc., and that's all potentially against your argument, then maybe what you do is argue for the simple approach advanced by the High Court in Mills and Meeking, where without being definitive, the court said there may be no reason to refer to extrinsic materials if the language is clear and the purpose is expressly stated in the Act. So maybe that's your approach, to say the High Court is saying in Mills and Meeking that you don't have to go beyond the clearly stated purpose, so the clearly stated writings, words in the Act, if that purpose is clear. Just want to keep up your sleeve, and you may be arguing for and against these things depending on the day of the week. Another one is North Australia Aboriginal Justice Agency against Northern Territory. I haven't mentioned this case before, but it's 2015 HCA 41. And in that court, the court said at 86, extrinsic material does not displace the text, but can illuminate the meaning conveyed by the text. Therefore, the court may consider, but not necessarily adopt, at least in full, the content of extrinsic material. So again, that's a case where it goes a little further than Mills and Meaking, but it basically indicates that extrinsic material can be considered, but it certainly doesn't displace the text. It may help in the meaning of the text. Therefore, the court may consider, but doesn't necessarily have to adopt, at least in full, the content of extrinsic material. So, an example, the court is trying to interpret the word, I don't know, premises. One counsel is arguing that in a specialist report, an expert report prepared in the process of the legislation coming into existence, there was discussion about what is meant by the term premises. The expert writing concluded that premises means this. If you don't like that approach, if that's against your interest, then you want to have that quote by the High Court in relation to North Australian Aboriginal Justice Agency against Northern Territory up your sleeve. Okay, so what we've been talking about in the first half of tonight's discussion is how you introduce extrinsic materials in circumstances where it may not be obvious that the court should accept that material. What I'm now doing is looking at it from the other perspective, saying you don't want that extrinsic material in, and you're trying to advance an argument to suggest to the court that whilst it may consider that, it doesn't have to. It's perfectly acceptable to not consider it or to consider it, but not necessarily adopt it. Does that make sense? So these are things that you need to have ready to go if you're arguing a case. I hope I haven't been too obscure on that. Have you followed what I've been saying? You're probably afraid to say no for fear that I'll repeat it. Thank you, Sarah. Yes, Sarah?
John, would it be possible for you to just type that note of the references up on UCrew, just because making notes of it while you're saying it in the lecture is a little bit awkward? John, your mic's on mute.
Sorry. It's only the third time I've done that tonight, I think. I will make a note to do that, so thank you, Sarah. And if I forget, please let me know. Okay. So, there's some judicial comments that you might consider. When you did your work in relation to CIC insurance against Bankstown Football Club, you were considering the issue of context in a wide sense, weren't you? Okay. So let's think about extrinsic materials used by the court in that case, in the context of what we're talking about tonight. So the outcome in the CIC case was that when the court considered Section 58, it looked to the mischief that the statute intended to remedy. And in that case, the Law Reform Commission report held the answer. It stated that the Act is put in place to prevent a person from overlooking the expiry of a policy and to prevent an insurer from not providing reasons as to the non-reviewable policy. That was kind of what it was all about. Even though on its face the legislation was not ambiguous about the provision, the court found that in that case the policy had been cancelled prior to expiry, and it was not a policy that was set to expire, and consequently the statutory policy never arose. So what was important about that case in the context of extrinsic materials is that the court did have regard to law reform bodies to ascertain the mischief to which the statute was intended to cure. It provided a clear approach to the modern methodology for statutory interpretation, and it considered the context initially and not necessarily later where an ambiguity arose. In other words, there wasn't necessarily an ambiguity, but the court was prepared to dig deeper. All right. So law reform commissions used reports used in the CIC against Bankstown case. I'm going to refer you to, I think, a very good publication. It's by the Parliamentary Council of Western Australia, and it's a really easy to read introduction. I think I may have mentioned this previously. I'm going to share the screen so you can look at what it is that I'm talking about. And this would be extrinsic material, clearly, but it might just help in terms of your studies, and it might help in terms of something you can put forward to support an argument. So, how to read legislation, a beginner's guide, Parliamentary Council's Office, Western Australia. It's a little age, 2011, but I think worthwhile, particularly those of you that are in Western Australia. Can you read that? And it goes on for a number of pages. I think I refer to this in Introduction to Law. Okay, so just a bit of an aside. Also, access to Hansard. I'm sure by now you all know how to access Hansard, but there
John?
Yes.
Will you put a link up for the document you just brought up on UCRU as well?
I will, yes, I'll do that.
Hello, my name is John Milburn.
Oh, sorry, there I go. And so that's just a YouTube clip that I did on accessing Hansard. You've probably found that already. And of course, you should now know exactly where it is that you want to go to check out explanatory memoranda, explanatory notes and statements, either through OSLI or through the authorised sites. You should also know where to look to find treaties. And one place that you can consider is OSLI has a treaties database. You may or may not have come across this. I'll just share the screen. Sorry, it's through the Australian Government Department of Foreign Affairs and Trade. If I just share the screen now, you should be looking at the dfat.gov.au treaties page, and that's a database where you can find information about treaties by subject, agreement type, country, search for words, etc. So I'll provide you with that link as well. All right, so coming back to a question, if you're working in a law office and you come across a problem and the client wants a response, you've got some pressures here. The pressure is that you need to provide an answer quickly, it needs to be accurate, and it needs to be provided without too much effort, because the time you spend, the effort, should translate to time on a timesheet, which should then become a bill. So if you spend 20 hours researching a particular point, the client may not want to pay for 20 hours worth of work, and your employer may not be too happy to pay you 20 hours of time if it's not being billed. So you're under all sorts of pressures. Again, I come back to that distinction between trying to determine something which is based on plain English as opposed to looking at extrinsic materials. And it's a balancing act, and it's pretty hard to do. But if you're challenged, let's say by your client or by your employer, as to why on earth you're wasting time looking at reports from parliamentary council or committees, how do you respond to that? What's your response as a first-year lawyer? Any thoughts? developing the best argument to suit your position, says Sarah. Yep, I agree with that. Perhaps a simple way of approaching it, just keep this up your sleeve, is if you're challenged as to the extent of material that you are researching, why are you researching this? The simple answer is because if it goes to court, the judges will do that, because that's what the judges do. And if your employer or your client says, well, how do you know that judges do that? You say, well, have a look at section 15AB. It provides clearly that the courts may consider extrinsic materials. So if we want to do the job properly, I also have to consider the extrinsic materials. What we don't want to do is rely on something that appears to be unambiguous, only to find that extrinsic materials take the methodology in a different way. I know these are tough hypothetical questions, but I'm really just trying to get you to have your toolkit ready so that you're ready to practice and answer questions, not just of judges, but also clients and employers. Does that make sense? It's all good? All right, thank you. So clearly, legislation should be drawn so that people can understand it, and it should be drawn on the basis that a citizen reading legislation will know what the law is without having to look at Hansard, explanatory notes, second reading speeches, expert reports in standing committees, etc. So there is a clear distinction between what should happen, ideally, and what may happen in a court context. So remember those rules about limiting the extent to which you undertake searches if what is gained is insufficient for the work that has to be done. So sometimes it's a case of the harder the problem, or the more that's at stake, the more that you need to delve into extrinsic materials. So then maybe that's something to consider as well. Okay. So Sarah was saying that So the toolkit that you provided or provide for your assessment, you probably need to supplement that with another one because of the word counts. Yeah, that makes sense. All right, so are there any questions about what we've discussed tonight? I know it's been a lot of me talking, but you've done well. All right, got some questions for you. We're ready on the buzzers? Okay, question 1. This is A, B, C, or D. What I'd like you to do is to type your response on the chat facility. So listen carefully. The question is, extrinsic materials are A, statistical and quantitative data generated by lawyers. B, exemplar documents from England which lay the foundation for statutory interpretation in Australia. C, almost any relevant document excluding the text of a statute. Or D, none of the above. Okay, a variety of answers. The most common answer, C, and that's the correct one. So extrinsic materials, almost any relevant document excluding the text of a statute. That would include dictionaries and the writings of academics. But have your arguments ready to support these things. Okay, well done. Now, question 2. What is the key legislative provision on the use of extrinsic materials in interpreting Commonwealth legislation? A, Section 15AA of the Acts Interpretation Act. B, Section 15 of the Australian Constitution. C, Section 15AB of the Acts Interpretation Act. D, Section 34 of the Interpretation Act, New South Wales. Oh, we're on to this one. We've been listening carefully. Everyone got it right. C is the answer. Okay, we ready for the next one? Question 3. Can a court make use of extrinsic materials even if a statutory provision is clear based on the ordinary reading of it? A, yes. B, no. C, only if the explanatory memorandum provides for this. D, only if the parties put the material before the court during submissions. The votes are coming in. And there's a common theme. Oh, well done, everyone. Everyone is correctly saying A. Good work. We're ready for question 4. Question 4. Extrinsic materials can be used to A, confirm that the meaning of a provision is the ordinary meaning. B, determine the meaning of an ambiguous or obscure provision. C, determine the meaning of a provision where the ordinary meaning would create a manifestly absurd or unreasonable result. Or D, all of the above. Oh, quick fire answers, and you're all correct. Well done, D. Perfect. That's great. You're doing well. You're doing very well. Question 5. We're getting close to the end. The law on use of extrinsic materials in statutory interpretation is found A, in statute form, B, at common law, C, both of the above, D, neither of the above. Very good. You're all correct. C is the answer. You're quick on the buzzers too. And there's some good races going on in terms of who's getting in their answers first, I can tell you that. All right, so number 6. Which of the following descriptions does not apply to extrinsic materials? A, relevant, B, determinative, C, optional, D, informative. This is a much harder question. We've had a spread of answers. Those of you that said B are correct. So what we're saying is that determinative is not a word that properly applies to extrinsic materials. Extrinsic materials might be relevant, but in the context of determining, in the context of a court considering extrinsic materials, they are optional and informative, but the extrinsic material does not determine the answer. The court will determine the answer. Number 7. The Commonwealth interpretation legislation lists a number of types of extrinsic materials. Which of the following is not listed? A, parliamentary debates and explanatory memoranda. B, Law Reform Commission reports and Royal Commission reports. C, cases and dictionaries. D, treaties and international agreements. Oh yeah, very good. All coming in correctly with the answer C. Well done. Number 8, and this is the last one. So we're ready for the last one? A document which is tabled with a bill setting out the rationale and intention behind the legislative provisions is called A, an explanatory memorandum, B, a second reading speech, C, Hansard, D, a regulation. Very good. A is the answer. So the document tabled with the bill is the explanatory memorandum. The second reading speech happens later, but when the bill is tabled, it's the explanatory memorandum which accompanies it. Well done, everyone. So that's it for tonight. Before we wrap up, are there any questions, comments? I've got to upload some things onto Ucrew, which I'll do. Okay. Well, we'll wrap up for tonight. Thank you very much for attending. We look forward to seeing you next week at the same time. All the best. Bye.